Mr. Kennedy, when I read your plan, your plan is pretty vague, and I asked a lot about timelines last time, and we asked about time frame. And you ranged from 3 months to 6 months on the other motion to extend indefinitely or suspend indefinitely. But we talked about bringing your plan forward to this meeting, and I don't see any timelines on here. And last time we talked about a couple months or 3 to 6 months, and when I look at the plan that you gave us, that looks like a lot more than a couple months. Can you kind of expand on the time frame?
Certainly. The timeframes and the plan that is before you is dependent on the action of others that I can't prompt or guarantee. And so there is not a point at which my client would say that's enough, we're not going to keep trying. I don't think that exists. And when you back up from that reality, then we don't have a way to say, you know, after 180 days we're going to quit. After 270 days we're going to quit. I find that more unrealistic. And so there is not dates in the plan. I hope that's helpful.
There has been, I think, 47 days since the governor signed the bill on March 6th maybe. During that 47 days, what has Summit done to improve the route or improve acceptance of the route? Have you worked with the counties that have county ordinances? Have you worked with the landowners that are on your main trunk that haven't signed voluntary easements? What have you done during that time frame?
Commissioner, the Summit operation includes many people doing many things. I would not be able to recite and recount all of those things. My understanding is that I know there have been continued efforts, but to quantify those, I can't do that for you this afternoon, I'm sorry.
How will Summit continue to route a permit of the application of HP 24001 when even the entry from Iowa is an obstacle?
Thanks for the question, Commissioner. The process with any landowner is to determine the landowner's needs and preferences and make adjustments as you're able to do, and also to achieve accommodations on the price in order to motivate them to act. In some, I think the price of poker has gone up here considerably.
I don't see a possibility of having an indefinite extension. I just don't see how that's possible for us to say, yeah, we'll wait someday in the future for the shoe to drop and then we'll proceed with this. So continuing on a path that is in grave doubt, and all of this discussion from Summit during that period of time reflects that, in the opinion of Summit, that Summit doesn't even think that it can be accomplished. I understand you're in a heck of a position. I mean, you're between a rock and a hard place. 1052 made life miserable for you. I know that. But Summit came out then afterwards and started saying, hey, it's over, it's done with. So what are we as commissioners supposed to think? I'm having a lot of challenges seeing how you can comply with the laws at this junction. Your plan of action, as creative as it is, just does not show that you can comply with SDCL 49, 41B, 13.2, and the content that's in 49, 41B, 11.
asked the question in your initial presentation, what's changed in the last 12 days? Well, the one thing that I think is significant that has changed is the applicant has said, they're not gonna challenge 1052. We didn't know that 12 days ago, and to me, that's huge.
I
Would you agree?
100% agree.
What's the real harm to your clients about letting Summit see what they can do?
Well, I think with respect, that's answering the wrong question. I don't think we're here based on what a harm to our clients is. We're here based on what's the right decision to make based on the law. And a impossible, impractical, futile exercise of this just hanging out there. It's like watching a slow car crash. We can all see there's gonna be a crash. We don't do anything to alert anyone or try to stop it. We'll just let it play out. We know where it's going. So that's really the issue. Like, should we, and did the legislature intend for the PUC to engage in a futile exercise? Like, I guess in the last 3.5 years, I mean, what's gonna change to persuade these people? Mr. Kennedy said the price of poker has gone up, which suggests to me that you're just gonna, in the new offers, you're just gonna throw more money at the people, which then takes me to a question Commissioner Nelson asked in the Navigator docket, and I'm paraphrasing, after the testimony of one of my landowner clients, and basically, so you're telling us there's things more important than money. I mean, and that is why we are here. So the price of poker from a business standpoint, and now the new offers are gonna have bigger dollar signs, no one cares. And people don't care. And so I got a little off track on the question, but it all goes to the point is there's nothing they can do to change these folks' minds who, frankly, from their perspective, have been abused, disrespected, bullied for the last 3.5, 4 years. It's not happening. Step 2, yes, is there a possible route for this company with other landowners? I think there is, but it's not in this application. And yes, what has changed? I asked a poor rhetorical. I meant in terms of advancing Summit's objectives. A lot has changed. They're not going to challenge 1052. I hope that satisfies concerns that Commissioner Nelson had last time. And they're not going to change the route. I mean, that's double whammy. They can't do it.
Summit's route is uncertain at this point. We really don't know the route. We don't know the timeframes. We don't know their plan. We don't know their construction timeframes or even cost. The application is not ready to go forward. Summit Carbon Pipeline has a legal right to reapply for this permit with the PUC. And we will make our decision on every application that we get based on the law, not on politics.
One, we've learned that Summit is not gonna challenge 1052. That is huge. That tells me that many of those landowners that have been concerned about this are now off the hook. That's a big deal. If I were in Summit's shoes, I can't imagine trying to deal with the route that's in the application, and we haven't even begun to talk about the county issues that Summit still has. I mean, so to say it's very difficult, absolutely. And frankly, if I was in Summit's shoes, I'd want to start over with a new application. I think that would be cleaner.
I look at this from the standpoint that they're not changing the route, they don't have eminent domain, they don't have common carrier status, they have intransigent landowners on a very long portion of the route. And so as the motion states, they cannot comply with those two statutes. And we do have to follow the law. And the law states that they have to comply. And if I were a legislator, it would be probably a little more difficult for me. I might be looking at it from a standpoint, a personal standpoint of giving them a shot to go farther, but go further, excuse me. But I just I cannot do that. So I will be supporting the motion. Commissioner Fiegen,
Fiegen votes aye.
Commissioner Nelson,
Nay.
Hanson votes aye, motion carries.